Get started. I think we've got over 100 participants. Everyone, I hope, has had an opportunity to grab some coffee. Welcome. I'm obviously very overexcited to see everybody. Over 100 people in one place. It's quite surprising for me, because at the moment we've got 3 people in our house: a cat, a tortoise, and a guinea pig, and that's pretty much the long and the short of it. This is our inaugural One Chancery Lane Thursday morning webinar. We're going to roll out a timetable of these. So next week we'll have Zach and Justin talking about construction of contracts, which hopefully will be of wide interest to all our participants today. But today, navigating civil hearings in the midst of COVID-19. And this is Dominique Smith, obviously you can see on your screen, one of the rising stars of Chambers, I could say. And she is going to talk to us about the remote courts, remote hearings, how they're going, good things, bad things, little tips that make them easier. We know there have been some problems with Skype, and the court is just about to bring out its own platform. So we don't know what problems that will have, no doubt, a large number. Yet to know solutions to those, because we don't know what the problems are. But Dom will just give us a few tips about hearing bundles and navigating hearings themselves. For the purposes of the webinar, for those of you who haven't used Zoom very much before, you get obviously a couple of pictures of Dom and me. Once I've stopped speaking, I will then mute myself, so all you can hear is Dom. You are all muted, I'm afraid, so nobody can talk to us. The way you communicate with us is, as some of you have already seen, there is a line of buttons at the bottom of your screen. And if you look along the bottom, there's mute to the immediate left, then stop video, which you don't need to do because Dom's done that for all of you. Participants, you'll be able to see which of your friends are here today. A Q&A button, which is an important one for today's purposes. I'll come back to that. There's a chat button that we've all been using to talk amongst ourselves, and you can talk personally to other participants as well on that. Just be a bit careful about that. I've talked personally to participants, or thought that I have, and it's gone to the whole group in the past. So if you want to say anything rude about Dom or me, probably best not to use that one. The share screen button you don't need to worry about. The recording button you don't need to worry about. In relation to the Q&A button, we've already had some questions in, so thank you very, very much for the people who've provided us with those. Dom is going to answer those questions as she goes through. If you have any further questions, or you just want to ask something about anything that Dom raises, anything about hearings, anything about the technology, I will try and answer them as we go through. So any questions, if you use the Q&A button, and if you identify yourself when you ask the questions, that means that we'll be able to get back to you if we don't get a chance to answer the questions as we go through. So if you have any questions, I'll answer them. Dom will answer them as well at the end. There'll be time at the end, I hope, for you to answer a few questions or ask a few questions at the end, if you'd like to do that. But yeah, so fully interactive, and as many questions as possible, please, because it's always good to hear the questions that you have. And the questions that we got before the webinar were actually really, really good ones, really interesting questions that Dom's incorporated into the webinar. So hopefully all the answers there, but if not, feel free to ask questions as you go and I will answer them. Thanks. Dom, remote hearings.
Great. Yes. Thank you. So let's see if I can change the slide. Here we go. So as Sarah said, we're going to be discussing a number of things today, things such as HMCTS's priority county court hearings list, which some of you I'm sure have already seen. Secondly, if a hearing is actually suitable to be conducted remotely, and things that you can have a look at and factors that you can analyse to see whether it is actually going to be one that's suitable. Tech being used, as Sarah said, things to check before the hearing, and some tips and experience, if it's a way of the future. So let's see if we can get this to work. Here we go. So HMCTS's priority list. Many of you will have seen that HMCTS has effectively been changing the way that the courts work and operate to cope with the coronavirus pandemic. Some courts have been closed, such as Kingston and Edmonton. Others are operating, but are operating on a much more limited basis, in that they're just simply not dealing with every type of case that they usually deal with. And what HMCTS have done is they've effectively categorised hearings as being either priority 1 hearings, priority 2 hearings, or something not falling into that list at all. So you'll see here, this is a copy effectively of the guidance that's up at the moment. They are changing this frequently, so make sure that you check HMCTS's website frequently to see whether your hearing is now a hearing that does fall within a priority 1 or priority 2 category. But you'll notice from the priority 1 hearings listed, this is work that must be done. And you'll see that generally the hearings that are listed have an urgency to them. So things like injunctions, applications to displace under the Mental Health Act, homelessness applications and the like. But you'll also notice that there are applications listed there generally, so those in cases that are listed for trial in the next few months, so next 3 months specifically, and applications where there is a substantial hearing listed in the next month, as well as appeals and multi-track hearings where the parties agree that the matter is urgent. In terms of priority 2 hearings, that's essentially work that could be done. And you'll see that things like infant approvals, stage 3s and the like, and there are also some other types of applications there that are listed. Now, in terms of small claims and fast-track trials, it says there that they will go ahead where the parties agree that it is urgent. It's quite difficult, I think, in the circumstances to justify that a small claim or a fast-track is urgent. But there are some courts which, despite the lack of urgency, are listing a few small claims. So I know a colleague in Chambers has had a couple of small claims, and one as recently as Monday in central London, which took place via Skype. And there was a credit hire case, so there's no urgency there. But there are the odd courts that are dealing with those sorts of cases, I think, to try and clear the backlog. But most courts have just decided to blanket adjourn those types of cases and most trials until July, August or September. So that's something worth checking with the court. But also what is taking place and what's actually been something that I've been dealing with most since the pandemic and the lockdown happened is really case management hearings and CCMCs. There was a question that came in that asked whether CCMCs are going ahead remotely. That's been my experience. I know there are some others in Chambers who've also had CCMCs, and there's no real reason why it can't take place. With CCMCs and CMCs, they do sometimes take place remotely anyway and did so before the pandemic. And what you tend to find also is that the courts are considering that justice hasn't ground to a halt. So because of that, parties need some certainty as to what's going to be happening with the case, and they need to make sure that the case is actually progressing. So what they're trying to do is at least list dates in the future for parties to comply, so that ultimately everyone knows where things are going, the cases aren't reaching a stalemate. But it seems likely that, although this is the most recent list and they are being updated frequently by HMCTS, there's no doubt that when the courts get a better grip of technology and the cloud video platform rolls in, it's more than likely that more trials and the like will be starting to go within those priority listings. So if you do have a hearing that falls within the priority 1 or priority 2 listings, the next question you need to ask yourself is whether the hearing is suitable to take place remotely. And it's likely that most hearings will be suitable, but there will be a number that just simply aren't. From my experience the last few weeks, I think there's a few things that you need to investigate beforehand to make that determination. So firstly, the nature of the hearing. Is it a hearing that's particularly complex with multiple witnesses, for example, that is going to involve extensive cross-examination or allegations, for example, of fundamental dishonesty? That may mean that ultimately it's not something that's going to be suitable for a remote hearing, particularly if you have a hearing where fundamental dishonesty is alleged. Ultimately, it's such a serious allegation that a court may consider, the parties may consider that it has to be dealt with in person because of the nature of what's being alleged. You also have to look at, we've already talked about urgency, but the number of parties participating. And no doubt you've probably seen, there have been reports from the commercial courts, for example, who are widely promoting the fact they've had very successful Skype for business hearings with multi-party matters and the like. But when you're looking at whether that can take place in Slough County Court, for example, it's unlikely that that's going to work as well because the technology and the infrastructure isn't always there. And if you have a hearing, for example, a food poisoning case, where in the food poisoning case you have 20 claimants who are all bringing a food poisoning claim, and there are experts that are abroad who are supposed to be giving local standards evidence and the like, it may be that the court doesn't have the infrastructure, indeed it may be a bit too tricky with the sheer number of parties for that to take place remotely. In terms of whether some or all of the parties have access to the necessary tech. It seems a bit of a silly point or a silly question to ask yourself, but we've had experiences recently where some people just simply don't have the tech or the ability to be able to join the hearing, and that's something you need to bear in mind. There was someone in Chambers who had a case recently, and they were acting for the defendant, and the claimant was a 79-year-old elderly man who had hearing aids and did not have the internet or a computer to be able to access the hearing. So they made a conscious effort to inform the court of that. But strangely, the court said it was totally suitable for a remote hearing, and it got listed, but after an hour of the hearing taking place, it was adjourned because the claimant simply couldn't attend. It was a total waste of time. But what you don't want to happen is for the hearing itself to be adjourned when you're there and you discover this all on the day, because I anticipate your judge will be particularly annoyed. You want to try and make those investigations before the hearing actually takes place. As to expert evidence, this is something you also need to consider. So of course, with the pandemic at the moment, there are a number of doctors and nurses and the like who are on the front line, and they just simply aren't going to be available as witnesses or indeed as experts. And someone sent in a question beforehand saying, effectively asking whether clinical negligence trials are taking place remotely. And I haven't heard of one being taken place. It may be that one has, but it doesn't seem in the circumstances that it's going to be particularly likely, particularly if you've got expert evidence, because those experts are going to be disposed elsewhere, and your witnesses, or indeed the other side's witnesses, may not be available. But you may also have issues if your expert is based abroad, because as we know, there are a number of other countries that are in lockdown at the moment, and it may be whilst at home that they can't deal with the hearing, or they don't have the setup to be able to deal with that. So that's worth checking in advance. Tech is the next biggest thing on everyone's mind. Skype for Business, I was saying this to Sarah earlier, seems to be the platform of choice that the courts are really using at the moment, which is a bit bizarre considering that it's being replaced by Microsoft Teams. There are some Teams hearings taking place, but predominantly it has generally been by Skype for Business. And if you have a Skype for Business trial or hearing, don't fret that you actually need to have Skype for Business installed. What you will get sent by the court is a link to the hearing, and it's worth checking that in advance of the hearing, because what will happen is you'll get the link, and often it will have a download, effectively to download an add-on to your system so that you can access the hearing. And what you don't want to be doing at 5 to 10 on the day of your hearing is trying to download that, realizing your internet's being really slow, or that you need to actually shut down your computer and restart it to try and gain access. You'd like to ideally sort that out in advance. So if you are sent a link, and again with Teams, you may have to download an add-on, so it's something you need to look at in advance. The problems with Skype for Business, one that seems to be a difficulty with having separate meeting rooms, which seems to be much better on Zoom, where you can chat to your client separately and to the other side, and then have a room for the court. That seems to be an issue with Skype. But also, if you're a Mac user, it's particularly tricky. It seems that Skype for Business doesn't work well with Macs or MacBooks, and so your microphone just doesn't seem to work. And there have been some tips that have been posted as to what works well or how you can get around that issue. I haven't had success with that so far, and I know a number of others who haven't. So you need to have a look at that beforehand, but it may be then on that basis that you need to find an alternative platform for your hearing to take place. In terms of Zoom, I've seen Zoom used in the family courts. It's not something that's really being used particularly by the civil courts. I don't know if any of you have had a hearing by Zoom so far. The reason that HMCTS are not effectively using this as much as Skype for Business, or if at all, is because it has security concerns. And I'm sure a number of you would have seen over the news that there is an ability for others to hack in effectively to your meeting that you're running via Zoom. And the way you seem to really be able to get over that is if you actually just make sure that it's password protected, and then it seems to resolve the issue. But despite that, it's not being used as much as one would hope. So I actually think it's quite a good platform. The cloud video platform is coming in soon, and this is HMCTS's version of its own sort of Skype for Business Microsoft Teams. It's being rolled out in the Magistrates Courts and the Crown Courts as we speak. And there's no date as of yet as to when it's going to be definitively implemented within the civil courts, although we're told that it will be in the coming weeks, so I anticipate it'll be quite soon. There was guidance released yesterday from the Midland Circuit regarding the cloud video platform, and essentially it talked about, again, how you will get sent a link to the hearing, so it's similar to Skype or Teams or Zoom. You'll get sent a link to the hearing. And it says that ideally you should have Google Chrome installed. It seems to work better if you have Google Chrome installed. And it essentially has a share screen option as well as a share PDF. So you can, if the judge doesn't seem to have something that you have the ability of sharing that in the hearing. So hopefully that'll be something that irons out some of the problems that we're all experiencing with the other forms of tech, and hopefully that will work quite well and come in the coming weeks. As to BT Meet Me and telephone conferencing, we all have experience of using that before the lockdown even took place. The difference is that most courts, whereas you usually prior to the pandemic would have the onus on you to arrange the telephone conference, and you'd have to speak to Legal Connect or Cadatu to try and get that organised, and then they'll dial through to the court and you join your hearing. Most judges at the moment are using BT Meet Me, which is causing some difficulty with some judges trying to work out how to add participants or accidentally kicking off some participants when they're in the course of the hearing. It's worth checking, however, who is going to be making the call, because I had an episode recently where we had thought that we had to organise a conference call. We did so, and the judge thought that they were supposed to be dialing us, and so the lines were blocked. Thankfully, it seems that was right at the beginning of the pandemic, but thankfully that seems to be really being ironed out, because the courts are now explicitly asking for telephone numbers in advance. So hopefully you shouldn't have too many issues with that, but just make sure you double check who the onus is on to arrange that telephone conference. So what should you check before your hearing if you overcome all of those hurdles? First, definitely try out the tech in advance. As I said, the microphone issue seems to be a real problem with Macs if you have Skype for Business, but you also want to make sure that you and your clients, if your clients are being called as witnesses, know how to mute yourselves, unmute yourselves, and show your video or hide your video. That's particularly important because they are being asked to do so during the course of hearings. So you want to make sure that everyone's comfortable with doing that and they know where the relevant buttons are. So a test run in advance is really helpful. In terms of backgrounds, try and have a neutral background. You'll see Sarah's got a background of the intercourt. It looks very nice with the red arrows over the top. You want to make sure you just have a background that's not particularly offensive or is not going to cause any problems. There is a district judge at the moment who, quite obvious when you're in the hearing with him, is sat in his bedroom, because you can quite clearly see the bed and the dressing gown. And I probably wouldn't advise that you do the same. So just make sure that you're in a neutral space that's not going to cause any issues. And as I mentioned previously about the add-ons, you will get that via an invitation, so just test that out beforehand. With your witnesses, as I said, check that they can use the tech. It was funny, I did read on Twitter that someone said they had a hearing which was for Skype Business, and they were told that there were no issues and the claimant could use it, all fine. But when it got to the day of the hearing, the claimant couldn't remember his password to access his laptop, and so the hearing got adjourned. So there's even simple things like that you need to make sure you do a very test and check. I think the pressure of the situation of being in a hearing that's not in a courtroom per se is causing a lot of stress to clients, so it's worth just checking that out and making sure they're as at ease as possible. In terms of the oath, if you have a client who's going to be giving evidence, make sure that you find out, firstly, are they going to be taking the oath or affirmation? But if they are taking an oath, they need to have a copy of the holy book that they seek to take the oath on. So they would need to make sure they have possession of that, because there's no way that HMCTS can obviously transport that to them. So it's worth bearing in mind that they are going to need to have to order one, or if they don't have one in their possession, or indeed take the affirmation. And lastly, I said about narrowing issues between the parties before the hearing. It seems that that's a really paramount point, because there are a number of issues with the tech where you simply just get thrown straight into the hearing. So for example, if you click the Skype link or the Zoom link, it takes you straight in. Or indeed, if the judge phones you for a telephone hearing, you're straight in there. And actually, there's no way of having that pre-trial conference that you would normally have, or a pre-hearing conference, or discussions with your opposite number as to what is or is not in dispute. And I had yesterday, funnily enough, a hearing where my opponent joined and said to the judge that they weren't taking any issue with our application, and that was the first it mentioned. Totally cheesed off the judge, because the judge thought there was absolutely no need then, I think, therefore, for the hearing to have even really taken place. So make sure you just check these things through, because if you then get to the hearing and actually you're both ending up having to talk over each other and say, no, that isn't in dispute, or no, that is, it causes huge problems and just leads to a grumpy judge. So when you actually get in the remote hearing, touched on this already slightly, what you want to make sure that you do as well is make sure that you have a well-paginated short hearing bundle. There are a number of issues with bundles at the moment which are just not coming in the correct format, or indeed aren't paginated, and judges are then going through and trying to paginate them on the phone, which when you're trying to do it with a PDF can sometimes be a bit of a nightmare. So make sure that you sort that out, and that you have everything nice and simple and clear and plain for the judge in advance of your hearing. But also make sure you file them way in advance, as much in advance as you can. Don't assume that the court have everything, because most judges do not have everything at the moment. They're lucky to have a bit of what you're looking for, what you're arguing about. So you need to just make sure that actually everything's given way in advance. If you do have case management hearings, which most of those are going ahead as planned, bear in mind Practice Direction 51ZA. So this is the new practice direction, which extends extensions of time between parties without permission of the court to 56 days rather than 28 days. Most judges are incorporating this into orders, or indeed are expecting you to have incorporated it into an order before the hearing takes place, just so that's plain for everyone. I have had one judge who's refused to incorporate it, saying that everyone can read and knows where the practice direction is, and they didn't want to write it out. So occasionally they may not put it in, but it doesn't mean that it doesn't apply. Some firms I've found, and some opponents are asking for stays, or even some of my instructor solicitors are asking for stays in respect of case management. And from my experience, stays are not actually being granted at the moment. This comes back to the point about the wheels of justice not really grinding to a halt. So what I'm finding that the courts are doing is actually granting stays in all but name. So they're incorporating the 56-day extension that could be agreed between the parties into the order, or expecting you to have done that, or at least acknowledging that that applies. And then they are pushing case management dates back, way back until September, October time for disclosure and the like, just so that actually it effectively is a stay, but they're not having to specifically order a stay, and that way it shows as though that cases are proceeding. So I think otherwise many stays would be granted, and it wouldn't actually be that productive to anyone, because we just don't know the uncertainty of the situation at the moment with lockdown, what's going to be happening. And indeed, expert evidence, if you've got a case management hearing, bear in mind that if you are seeking expert evidence, medical expert evidence, for example, in PI cases, that your experts are likely to be indisposed, and it may take some time for those appointments to be arranged. I think most people are conscious that it will be arranged at some point, or indeed are trying to have virtual meetings and the like, but there are always concerns there that if if meetings between experts don't take place face to face with a claimant, for example, there are always concerns that that may lead to people trying to exaggerate their injuries. So most of the time, I'm finding that actually they're just pushing the dates back so far with case management that expert evidence won't need to be given for some time, to allow for the lag and the backlog for experts to deal with the expert reports. So some tips and experience, hopefully we've been giving as we go along. Email and WhatsApp. So there's 2 points actually about email, which I'll come to. Firstly, if you have a hearing which you would normally be sitting in anyway, if not participating, of course, you need to make the court aware that in advance that you want to join. There's no reason why you shouldn't be allowed to join, particularly if you have CCMC, where you've got a cost draftsman and counsel. you want to make sure, in effect, that you can communicate with each other during the course of the hearing. Best way to do that, or for counsel to take instructions, or indeed if you want to tell them a point, is to make sure that you have an email going at the same time, or a WhatsApp group where you can allow those instructions or discussions to take place, because we don't have the ability to telephone in the course of the hearing. So it's quite handy to have that going so that you don't actually have a problem then, therefore, of getting those instructions through. And the point I made about email is that we did have a question in about if a judge doesn't have a document and you're listening to the hearing, you turn up to the hearing, the judge makes plain they don't have that document, are they simply adjourning hearings? And it seems that it depends. So I've had mixed results on that. If the document that you've got is something that's quite short, can be read in a short period of time, and you've got plenty of time left within your hearing for the judge to read it and deal with it, then you can just simply email it to the judge, offer to email it, and they can deal with it then and there. The hearing does not need to be adjourned. If the judge, however, is missing most of the court file and is missing the entire application or entire witness statements, and you say to the judge, look, I've got separate PDF copies, can I just email them to you? The judge may say that we've got half an hour, we're already 10 minutes in, I don't have these documents, I can't possibly deal with this in 20 minutes. So bear that in mind, that actually it's always worth having your emails on at the time when you're actually doing, of course, you're actually dealing with a hearing, but making sure that if you, you don't actually say at any point to the judge, I'm sorry, I can't deal with that. If you go in prepared and you know that you've got those documents, then it shouldn't be adjourned. But if they're so big and your time slot is so small, then actually it may be that the matter does have to be adjourned. Make sure, I've already said, if you have a decent electronic bundle, and as already stated, don't assume that the judge has the court file because they often don't, and it's all a bit of a mess at the moment. But be patient with your judges because we're all in the same boat at the moment. Are remote hearings the future? Well, this is quite an interesting one. We've had quite a few questions about this already in terms of whether we think that courts are going to go back and have social distancing measures in place and the like. It seems as though, in terms of remote hearings generally, it's more than likely that this will be something that we see much more of in the future, because no doubt HMCTS will say it's worked quite well. We've all adapted to it, and we know that the justice system was a bit behind in terms of tech anyway. But there are a number of hearings I just simply don't think should take place virtually by way of being the norm. So, when you have your fundamental dishonesty trials, or indeed some trials anyway, just don't seem to really be better suited to taking place virtually. I think it'd be a real shame to lose that court experience by having those matters dealt with outside of the courtroom. In terms of social distancing, we all know how long it took for HMCTS to put hand sanitizer and soap in the courts, so it might take some time. And the problem is that most of the courts are like GP waiting rooms. You've got lots of people in a small space, which may mean that it's a bit difficult in terms of socially distancing when you've got your clients and your opponent, you're trying to take instructions. So it remains to be seen how they can favourably carry that out. I think there's probably going to be some difficulties, because I can't imagine if you've got a case where the nature of the case is quite sensitive and you've got your opponent that's standing 2 meters away from you, that you shout some instructions about the case to each other or your points to raise. I don't think that's going to work quite well. So it seems as though that might be a bit of an issue. But other than that, I think, yes, the only other point was, are video hearings going to be the norm? Possibly some. I think, as we all know, CCMCs, CMCs and applications, no reason why they can't take place by video. It's trials where we're going to see some difference. I think possibly they may list in the future some small claims, for example, virtually, because they're not particularly contentious and they're quite easily dealt with. But other matters, other trials are a bit more complex. I think will have to take place in person, unless Sarah has any other views. No. Okay, I know that a number of questions have been raised, and some people were raising their hands and the like. But I don't know if anyone has any particular questions or wants to raise their hand and have a chat with us about how things are working or what they feel. Okay, so I've got Christina. Let me find you, Christina.
Just while I do that, sorry, just while I do that, it's quite an interesting comment made while you were going through, that someone's got a trial, 5-day trial in Exeter, and who's on a judge before, has ordered that it should be heard remotely, who I know you have history with.
Oh, I do.
has said that it's going to be done remotely. It's a 5-day trial, hot and cold running experts, and he wants it done and dusted in 3 days. Have you got a view?
Well, the problem is that remote hearings are taking far longer than normal anyway. You have to have far more breaks. They're far more tiring. And I can't see that that's going to take place in 3 days. I just don't think that's likely.
But I don't know what you do. The judge has said that it will. I guess you've got to try.
You can make, I guess you can make submission to the judge as to why you think in advance that you don't think the matter's suitable. Knowing Gore, he's going to pay absolutely no attention to that whatsoever.
Yeah, that's what I thought. Anyway, sorry, I interrupted.
All right, I did have a hand raised from Christina, but I think she's disappeared. And I think Ella's just raised a hand. Let me allow you to talk. I've got to try and figure out how this works. Okay. Ella, here we go. Can you hear us, Ella? You talk? No? Okay. Sarah, strangely, you've been muted.
I've unmuted myself. I'm fine.
Okay, there we go.
Have you had experience of connections, Oliver Wright wants to know, dropping out mid-hearing? If so, what happens?
Yes.
Thanks very much.
Yeah.
So
it does. Even in telephone hearings, I've recently found that every time I'm either connected to the judge or my opponent's actually connected, I get kicked out, and then I have this sheer panic of thinking, my phone's off, what do I do, who do I call? And eventually someone calls me back. And even with connection dropping, you tend to find, as long as, if you've got Skype hearing, for example, if the connection drops, just be patient, don't click out of it. It will just generally get up and running again. You'll eventually hear people when your connection becomes a bit more stable. I hope that helps. Does anyone else have any questions they want to ask? Feel free, we've got ages. I know you guys might want to get back on with your work though, which is totally fine. Oh, I've had Kirsty Jeeves. Kirsty, I'll try and allow you to talk, but it seems as though every time I do it seems to mute someone, either me or Sarah. Feel free to type it, Kirsty, if that's easier. I'm not sure it's going to work with letting me. It gets a bit funny when I try and let people talk.
Kirsty was asking about how members of the public access hearings. And I answered that with a non-answer in a very barristerial way by saying that I know members of the public can access hearings, and I know that you have to apply for a link, I think, from the court. Do you know any more about the mechanics of that, Dom?
I think it's a bit like if, for example, you're a solicitor and you want to join a hearing that you would otherwise not be participating in, but just watching. You just have to contact the court office and say, I want the access to this court. Some judges are getting a bit funny about it, but hearings are supposed to take place publicly. So as long as you make the contact with the court in advance and say you wish to join either as, solicitor or member of the public or whatever, I can't see why, if you make that sufficiently in advance, they can't give you those details. We all know the court office is a bit overwhelmed at the moment.
They've been really keen, though, to make the point that hearings are still taking place in public. So that's been, as well as access to justice, public access to seeing justice has also been one of the big issues around it, hasn't it? They've been trying to safeguard that.
Yeah.
The other thing that Kirsty was asking about is something that actually I find quite conceptually difficult, which is about the practice direction 51ZA. You may be able to see the chat now, where there's debate amongst her and her colleagues about whether or not it trumps CPR 15.5 extensions. So you still need to put in a consent order in relation to extensions of time for a defence. For what it's worth, my reaction to that is to say, well, practice direction, the amendment to the practice direction to CPR 51 is about a specific situation, this specific situation about COVID-19. Yeah. So I think it does trump the other parts of the CPR because it supersedes them, because it relates to the particular circumstances in which you find yourself. But I don't know if you've got any experience of that, Dom.
I don't, but I think that has to be right. It's a really tricky one there, as you said, conceptually. I can see why you'd want to put in a consent order just to make sure in case you have a difficult judge trying to take a totally different view, but I can't see why it wouldn't supersede it.
Yeah, I think so too. And then Stan Baring is saying, I thought I saw something that BT can't arrange any more telephone hearings as they're overloaded.
Well, I had a BT Meet Me telephone hearing yesterday, so it seems as though it is working. It may be that some of the courts are now, cause I find with BT Meet Me, the court has your number, and I don't know how they quite do it, but the judge says, I'm going to dial out to the party, like your opposite number now. It may be that they're now trying to put a stop to that and organising Cadastre or Legal Connect, but the problem is that they're just as overloaded as everyone else. So I can't see why they just put a stop on those sorts of hearings. I think they'll allow them to keep going ahead, and they'll try and organise as many as possible, but it seems as though they're working fine at the moment.
Yeah, I mean, the one thing that I've had is that the court, because the court broadband systems are so ancient and the technology was put in a long time ago and it doesn't seem to have really worked ever from the beginning, is that it's not so much the BT provision that's having difficulties, it's the courts that are having difficulties. So because some judges are actually sitting physically in their geographical location, so they're sitting in their courts. And sometimes the internet in the courts is just not good enough. But that's always been the case. I mean, we've had problems with that from the beginning. Those of us who video link to countries, it's always been a question of you're trying to video link to Turkey and you can't get through. You blame Turkey, but actually the Turks have got more modern technology or it's working better. It's us often.
Yeah.
So I have found that some particular courts have a problem, but that's more to do with the court building, I think.
Yeah, I mean, I've just seen that Sue Allen has posted that BT are not organising any new hearings from the 1st of May, which is pretty interesting. I think that the courts are just so overloaded, and that's part of the problem why they're going to be keen to try and revise the HMCTF listing and things like that and try and make the CVP work as best as possible, because if conference organisers such as BT are not going to be organising any further hearings and Cadastre and Legal Connect are struggling, then they're going to have to move to video hearings, whether they require your your video to be on, your webcam to be on or not.
Yeah, I mean, you probably saw, as I did, the memo that went round about the CVP, was it yesterday?
Yes, the Midland Circuit.
Yeah, and the memo that went round from their tech office seemed to say, we're going to try this, it might work, it might not work. Some of the features on it don't work yet, so you can't do things like playing 999 calls. You know, don't even attempt to do the clever things with it. The basics may or may not work. So if BT are not listing any more hearings, and if the CVP is going to have teething problems, which it seems it will, there's going to be a gap, isn't there?
Yeah. And I think it's going to add to the inevitable backload the court already has, which I don't know how they're going to really deal with it. I think we're going to be extremely busy.
Do you think they'll have blitz courts when we come out of this? Because you've been having blitz courts in various courts, like Central London has a blitz court from time to time.
Yeah, I think they're going to
see us all having blitz courts.
And I think they're going to be putting such an emphasis on case to settling and trying to make the parties come to an agreement, or they may even start to do some initial determinations of small claims on paper. I can't see why they wouldn't.
That's horrifying, Dom. It puts us out of a job.
Does anyone else have any questions? If not, I was going to say our email addresses, I should put this on the last slide. Our email addresses are there, so if you think of anything afterwards that you can't think of right now, then obviously drop us an email and we can answer them later. But hopefully this has been helpful. Fingers crossed.
Yeah, that was great. Thank you so much, Dom. Really, really interesting, really helpful. Slightly worrying from time to time, but you know, you've got to be realistic about these things. And thank you all for participating. It's really, really helpful if you raise questions, give us feedback. If you want to give us some feedback afterwards, then please do. It's good to know what we're doing well, what we're not doing so well. Anything you think could be better done for next week. As I say, next week, 11 o'clock, is Zach and Justin from 1 Chancery Lane talking about construction of contracts. So get your questions into them early and often, and we will see you all again next week. Thank you for joining.
Absolutely. Thanks all. It's been great. Stay well.